Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Video no may because of immigration rules, new rules be about a friend of part suitability. Part suitability are on the by 11th of November 2025. Adia a children say sɛ wowɔ suban bɔne bi a na ɛni sɛ yɛma w'asetena suban bɔne ne dɛn suban bɔne ne deɛ yɛ bebree but deɛ ɛha me wɔ mu ɛne sɛ sesia no ɔmo sɛ wa overstay ɛwɔ kurom ha na wofiri ha koraa for 1 year no wontumi mba back anaasɛ sɛ wa overstay wɔ ha na wowɔ ba ɔyɛ British anaa ɔba no wɔ indefinite stay anaa ɔba no wɔ EU pre-settled status anaa ɔba no atena ha 7 years a ɔmo sɛ because wa overstay no ebi a yɛbɛ refuse no yɛhu sɛ nkurɔfoɔ bi wɔ hɔ a yɛ refuse wɔ video yɛ a meyɛ sɛ woyɛ immigration rules application na woyɛ overstay a woyɛ illegal watra asetena yɛde maa wo no ho because woyɛ wɔ immigration application part suitability no ɛbɛyɛ affect nti obi a wa overstay ɛwɔ kurom a biara for more than 14 days na kyerɛ sɛ woyɛ overstay a na kyerɛ sɛ part suitability no woyɛ application na ɛbɛyɛ affect then na wobɛyɛ first of all sɛ wonim sɛ wa overstay na wogyina wo ba so na wode ayɛ application gye GP letter gye school letter sɛ woyɛ papa a gye letter free ne maame hɔ woyɛ maame na ekun no na ɔyɛ British anaa o ex-partner no na ɔyɛ British a gye letter free ne hɔ gye biribi a ɛkyerɛ sɛ wo ne akwadaa no nɛte wode ne pii mo wɔ pictures together GP letter no ma number letter sɛ mo nyinaa mo yɛ registered wɔ hɔ afei nso wodi no ba yɛnti America saa ne sɛ although sɛ parents ni bi wɔ hɔ a ɔmo mba no yɛ British sisi a na ɔmo yɛ application na ɔmo refuse ɔmo because ɔmo overstay ɛno nkyerɛ sɛ wa overstay a yɛbɛ refuse adeɛ kyerɛ ne sɛ wa overstay a ebi a yɛbɛ refuse nti wo na ɛwɔ sɛ woyɛ wɔ application no mu then na ɛwɔ sɛ woyɛ ka wanya GP letter school letter ebi a midwife letter community nurse letter ebi a asɔre letter anaa ɔba no bɔ football anaa ɔkɔ games anaa ɔwɔ any recreational group mu a wama ɔmo nso abɔ letter aka ho a ma ɔmo nka sɛ wode no ba saa group no asɔre ne saa nneɛma no nyinaa ɛno nso boa wawie no woyɛ wɔ application na ɛwɔ sɛ wotwerɛ detailed letter from beginning to the end no focus no yɛ wo ba adeɛ a woyɛ ma wo ba watwerɛ saa no connection a wo ne wo ba no wɔ a yɛfrɛ no emotional attachment ebi wɔ a na nyɛ sɛ wodi ne mpii nko a ba nkwadaa no bi wɔ hɔ a ɔmo yɛ so emotionally attached to ɔmo parent ne sɛ wuni ɔmo abrabɔ mu ɛbɛyɛ affect you sometimes no woyɛ bɛrima no na wogyina ɔba no so na wo ne ɔbaa no nkyia it may even be sɛ wɔ sɛ wonya social worker natural report ma but for now no me emphasis ne sɛ because of new law na aba na yɛ refuse nkɔfoɔ sɛ woyɛ wɔ application na mɛnyɛ no tra kɛkɛ ɛntwerɛ nkɔkɔ a sɛ wafɛle form na wode kɔ daabi saa de no yɛpa ho sɛ lawyer koraa na ɔyɛ ama wo lawyer no ma no ntwerɛ detailed letter don't go through because there were exceptions exception is the friend EX1A ebi yɛ article 8 ebi yɛ case of ZH Tanzania ebi yɛ a case of KO Nigeria saa cases ne nyinaa wɔ but wontumi nka case no kwa ɛwɔ sɛ wokyerɛ deɛ nti a case no ɛboa wo deɛ no na wafete wo case no within the law because office guidance notes no ka sɛ wowɔ family life ɛyɛ article 8 a ɛwɔ sɛ ɔmo hwɛ ebiom bibi de hɔ a yɛfrɛ no section 55 ebiom sɛ wowɔ ha as a skilled worker dependent na wa overstay for more than 14 days so lawyer abɛyi wo so ɛbɛkyɛw nti wo so woyɛ wɔ application a ɛwɔ sɛ wo justify deɛ nti a ɛne sɛ yɛ refuse so I hope sɛ wei ɛbɛboa mo but sɛ mmom mowɔ further questions a momfrɛ BWF ɛwɔ yɛ a numbers yɛ di so anaa mo google BWF solicitors ɛwɔ internet no so wobɛhu yɛ address ne yɛ details na momfrɛ yɛ and then the video no meka about British nationality naturalization and registration obi oba kromo ha bia betena bia ade a ɛda n'ani so ne sɛ daakye bia ɔbɛyɛ British citizen na kyerɛ sɛ ɔbɛyɛ application na ɔbɛyɛ British citizen na nsa na obi bɛyɛ British citizen yɛwɔ mmara a aban no ahyehyɛ a yɛfrɛ no the British Nationality Act 1981 saa mmara no ɛno na ɛkyerɛ kwan a ɔbɛfa so na ɔde ayɛ British na nyɛ no nko a yɛwɔ nhyehyɛ bi wɔ hɔ a yɛfrɛ no case workers guidance notes a ɛno na ɔmo hwɛ w'asɛm na ɛno na ɔmo so ɔmo hwɛ so ɛdidi w'asɛm yɛn nyinaa ɛbɛyɛ yɛn dɛ sɛ wobɛyɛ application na ayɛ successful nti ɛyɛ good sɛ application a wɔba abɛyɛ wobɛyɛ sure sɛ mmara no a yɛahyehyɛ no wobɛdi so. New guidance notes a aban no de aba ɛfa British nationality. Saa British nationality ɛyɛ registration anaa naturalization. Nhyehyɛeɛ ɛwɔ ho a yɛfrɛ no conduct anaa suban ɛyɛ bebree na ɛnɛ meetu m'ani asi mmiɛnsa so. Saa mmiɛnsa no ɛka ɛyɛ dɛn? Ɛka ɛyɛ sɛ obi akɔ bank akɔgye sika anaasɛ ɔwɔ account wɔ bank na yɛama no overdraft na wayi anaasɛ ɔyi credit card na wade ka anaasɛ ɔnni ɛkwan sɛ ɔbɛyi NHS no na wakɔyi na yɛama no bill na ɔntua. Home Office foɔ sɛ wode ka kɛkɛ a ɛno deɛ ɛnyɛ no na ɔmobɛgyina so deɛ refuse. Na mmom sɛ wode ka, wode bank ka, wode credit card foɔ ka, wode council tax ka anaa wode NHS foɔ ka na wantua na wanyɛ nhyehyɛe ɛmfa ntua a ɛno deɛ ɔmɛrefuse wɔ application. Na dɛn na wɔsɛ woyɛ? Deɛ wɔsɛ woyɛ no sɛ first of all, sɛ wode bank ka, wode overdraft, wode credit card ka, wode NHS ka, wode council tax ka, yɛn nhyehyɛe na sɛ tua nti yɛfrɛ no arrangement. Nti saa arrangement a wɔyɛ no wobɛgyina so sɛ ɛnɛ yi mene sika a mede bɛtua na mmom sɛ menyɛ sika ɛnkyɛ biara na menya a ebi abosom biara mɛtua £10 anaa £20 anaa £50 na wo ne ɔma yɛ saa nhyehyɛe. Deɛ nti ɛte saa no sɛ aban ne sɛ wofa suban bi na wode aka bosea na wabobɔbobɔ bosea saa wɔ bank na mmom suban bɔne nti no wontua saa aka na ɔmo so no ɔmo mma wo British nationality. Yɛmpɛ sɛ obiara te aseɛ no sɛ British nationality no ɛnyɛ ɛhyɛ. Nti aban ne sɛ ɛnyɛ ɛhyɛ no nti no wobɛyɛ a ɛwɔ sɛ wo ho ɛyɛ korɔgyee wode ka a wotua. Ɔmo gye council tax a ɔmo ntua anaa obi wɔ hɔ a no ne ne ku anaa ne yere ne te na waka sɛ ɔno nko ara nɔte na ɛma no 25% discount anaa obi wɔ hɔ yɛ student wɔwie university no anaa wɔwie school no ɔnka nkyerɛ council no ma ɔmo nsesa because students ntua council tax. Obi ɔte fie biara a ɔwɔ council tax anaa wɔatwa ntorɔ akyerɛ council no anaasɛ wandi ne ho ni ntua ne credit card anaasɛ wakɔuse NHS nyɛ wo GP yɛ free. Obi a wote ha biara wowɔ asetena wonni asetena wobɛtumi ayi so GP. Na mmom sɛ GP yɛ referral sɛ kɔ ne yɛnsa wo yareɛ ɛwɔ hospital na wokɔ hospital ɛkɔhu specialist a ɛno ne yɛfrɛ no treatment ɛno yɛfrɛ no secondary treatment ɛno no deɛ so tua. Nti ɛno no ɔmo brɛ wo ho receipt anaa invoice a wonni sika a ɛwɔ sɛ wo ne ɔmo hyehyɛ na wotua. Wantua a nso bɛrefuse wɔ application. I hope sɛ wei bɛboa wo bi. Kɔdodoɔ naa mowɔ ha no mo nyinaa mopɛ sɛ moyɛ British. Sɛ mopɛ sɛ woyɛ British deɛ a ɔmo sɛ ɛwɔ sɛ ɛka no a wode no wotua anaa wayɛ nhyehyɛ a wotua. Sɛ wopɛ advice about British citizenship anaa wode ka anaa biribi si wo kwan na wopɛ sɛ wobɛ advice a wobɛtumi afrɛ BWF solicitors about British nationality anaa registration anaa naturalization. Your numbers in this.
Successful customary proxy marriage application without leaving the UK. Case brief. The client came to the UK in January 2023 as a dependent partner of a skilled worker. Unfortunately, the relationship broke up because her husband had met another woman. The husband reported their relationship breakdown to the Home Office, and our client was sent a revocation letter, giving her 60 days to find another visa route or leave the UK. She met her childhood boyfriend, who had been pursuing her since she arrived in the UK. Challenge. They decided to get married. However, because the time available to her was short, we advised them to ask their family members in Ghana to undergo a Ghanaian customary marriage. The family subsequently contracted the marriage, and it was registered at the District Marriage Registry in Ghana. Neither our client nor her husband was present at the ceremony. In November last year, 2025, she brought her application for us to send to the Home Office. Strategy and solution. Under UK immigration rules and case law, Ghanaian customary law marriages are recognized as valid if the process complied with Ghanaian law, even if the man and woman were not present at the marriage ceremony. We prepared a detailed representation and submitted her application. Process and timeline. She enrolled her biometrics on the 12th of December 2025. Outcome. Our client was granted 2.5 years as a spouse on the 1st of February 2026. Nugget Ghanaian customary law, proxy, marriage, is recognized in the UK, even if the parties were not present at the ceremony. The process must follow Ghanaian law, including registration and certification. Always seek legal advice from professionals who understand the laws of England and Ghana. Facing complex immigration issues? Contact BWF Solicitors today. Client success. A skilled worker, dependent granted leave to remain despite his overstay. Case overview. Navigating a complex path to successful leave to remain. Our client was a dependent partner of a skilled worker with an initial leave to remain until 2027. Unfortunately, his partner's employer canceled her sponsorship. They both received a letter from the Home Office canceling their visas, which were due to expire in December 2024. His partner found a new sponsor, who issued her a new KOS in December 2024, with 3-year sponsorship. She applied for further leave to remain before the end of the visa cancellation and was successful. Sadly, our client did not make his application. By the time we took his case, he had overstayed by 10 months. He explained that he didn't know he had to make a new application. The challenge. Seeking to convince the Home Office to exercise its discretion in his favor. We made his application as soon as we received his instructions. We prepared a detailed cover letter to explain why the Home Office must exercise discretion in his favor, despite his having overstayed for more than 10 months. Our strategic approach for a successful application. We relied on the Home Office's discretion, explaining why he thought he didn't have to apply for further leave, although his wife had. We relied on the Home Office guidance and supported our representation with factors highlighted in the guidance notes. The updated Home Office guidance confirms that discretion may be exercised where the delay was beyond the applicant's control, or where the individual acted in good faith and has otherwise demonstrated compliance with immigration law. The outcome. Granted 3 years leave to remain. Our client was granted 3 years leave to remain just a week after enrolling his biometric data. Takeaway. Caseworkers may be able to exercise discretion under exceptional or compassionate circumstances where the application was submitted after the 14 days set out in exceptions for overstayers. You must always consult a lawyer when faced with such a complex issue. Facing complex immigration issues? Contact BWF Solicitors today. Ex-skilled worker dependent switched to 5-year partner route with a new British partner. The skilled worker's ex-partner successfully applied to switch to a new spouse visa as the spouse of a British citizen. Case overview. Our client came to the UK in 2023 with her husband, who was a sponsored skilled worker. Unfortunately, their marriage broke down because she met a new partner. The challenge. Divorcing and marrying within a short time. Our client had received a letter from the Home Office stating that her ex-husband had reported that they were separated. She was given 60 days to switch her visa or leave the UK. She was advised that, as they were married in Ghana, she could file for divorce in Ghana. She followed our advice and obtained a court divorce from Ghana. She subsequently entered into a customary marriage in Ghana. proxies represented her and her new husband. Once the marriage was registered in Ghana, she was ready to make her application without leaving the UK. Our strategy. As a result of the visa cancellation, our client needed to act quickly. We advised her about the lawful way to obtain an overseas divorce under the Family Law Act. Additionally, we ensured that the subsequent marriage complied with the stringent UK laws regarding the validity and genuineness of the relationship. With our vast experience in family and Ghanaian law, we ensured that she had the best chance of success. The outcome: spousal visa, granted within priority processing. The spouse visa was granted within priority processing timeframes, enabling the new couple to move forward with the marriage. This case illustrates how speed and knowledge of family and Ghanaian laws can be effectively leveraged in time-sensitive cases, particularly for dependents facing visa cancellation. Facing complex immigration issues? Contact BWF Solicitors today.
Good afternoon and welcome back to another edition of the Community and the Law. It's another beautiful Saturday, but it is very hot and I hope everybody is keeping safe, having water and fans with them wherever they go so as not to get dehydrated. Anyway, welcome once again to the Community and the Law. I am your host, Pamela Oakley. Today our topic is a very, very important one. We have had a lot of questions on this topic, a lot of people who come from their home countries to the UK and for some reason have fallen out with their spouses ask, can I get a divorce in the UK although I married from abroad? I got married to my partner from my country. We came to the UK and now we are no longer together. Can I get divorced to the person in the UK although we did not get married in the UK? This is a question we get a lot of the time, and we have our very knowledgeable resource person, Charles Asma, who is going to take us through this topic today. But before we get into that, we also will look at some of the updates we've got and the nuggets, and we would also look at the answers to the quiz question we gave you to see who was right and who was wrong. We are going on a short break. When we come back, we would have a look at our updates, our nuggets, our quiz, and we'll get straight into the topic. Once again, welcome to the Community and the Law.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to another episode of the Community and the Law. So our first update for today is wrongly stopped at the UK border, you could be entitled to compensation. So the High Court has ruled that the Home Office acted unlawfully by failing to remove an incorrect stop marker from its warnings index, resulting in a lawful migrant being wrongly stopped and detained at Heathrow Airport. The case is a reminder that the Home Office must follow its own policies, and individuals who are wrongly detained at the border may have grounds to challenge the decision and claim compensation. This update is coming from the case of R. Davis versus the Secretary of State of the Home Department. So we would go to Lawyer Charles to explain what this update is for us.
Yes, thank you, Pamela, and good afternoon, viewers and listeners. So, for the update, there is what we call marker or stop marker. A stop marker simply means that if somebody is required not to leave the UK or required not to enter the UK, there will be a red flag alert on the system. So that anytime the person is going through the airport, be it Gatwick, Heathrow, Stansted, wherever, the person will be flagged up and the officer at the borders will be able to pick it up. If it's entry, the person will be stopped from entering. If it is leaving the UK without permission, for example, you may be going through proceedings, criminal proceedings, and there's a stop marker to prevent you from running away from the UK before the proceedings are over. If you get to the airport leaving the UK, the stop marker will prevent your ability to get through and leave the UK. So this is how stop markers work. Now, if somebody has been flagged up through that stop marker and the process is over, they are supposed to remove the marker. If for whatever reason they leave the marker on, then that will be outright negligence on the part of the officer and the Secretary of State to a large extent. And so, if a stop marker has been left negligently on your file and that has created inconvenience for you, embarrassment, harassment, or what have you, then it will be the case that the officer who is acting on behalf of the Secretary of State has acted wrongly simply because the information available is not genuine or valid, and the reliance on that information has created that problem for that individual. And the question will be who caused that? And the blame will be placed at the doorstep of the Secretary of State, because Secretary of State is the one managing all these officers. And therefore, if something like that has happened, the the alert is that you can go to court and sue the Secretary of State for negligence, for inconvenience, for harassment, or whatever word you want to use, and consequently sue for compensation to more or less compensate for your inconvenience or whatever you've gone through. So that's a civil right or civil remedy that is available for anybody that may be placed in that situation. And of course, to do that, you must make sure that you have a case to pursue. So that is the alert or the update.
Okay, thank you so much, Lawyer Charles. We've got our second update for today. This says fast track British citizenship is now available. So this is good news for a lot of people who are going to apply for their British citizenship. So it says the Home Office has introduced a new nationality priority service, allowing eligible applicants to request a faster decision on their British citizenship application. What has changed? Applicants can now choose a priority service for an additional fee of £500. The Home Office states that applicants using the service should normally receive a decision within 30 working days after providing their biometrics. And now, is everyone eligible? The priority service is available for eligible nationality applications. However, not every case is suitable for priority processing, particularly where further inquiries or complex issues arise. The Home Office also retains discretion to prioritize certain cases based on exceptional or compassionate circumstances. Our advice is, if you are planning to apply for British citizenship, it is worth considering whether the new priority service is appropriate for your circumstances. At BWF Solicitors, we can advise you on your eligibility, prepare your application, and help you decide whether priority processing is the right option for you. So this is good news. Laura Charles, do you have anything you'd like to add on this?
Yes. So at the moment, there is no priority service for naturalization applications. So you wait for about 6 months, thereabout, or average, and you get your decision. Even if you have the money to pay, there is no opportunity. And to make it fair, the government has opened the floodgate so that those who can afford can request their visa application to be expedited or prioritized as far as the decision is concerned. And from this point, if you are applying for naturalization, you see the two options: standard, priority. Once you select priority, you pay a £500 priority service fee, and you have your decision within 30 days, give and take 1 month. Question: is it for everybody? Answer: no. The reason is that there are some people whose background or situations are not so straightforward, and so the caseworkers may need time to go through properly. For example, if you're applying for naturalization and you entered the UK illegally, the law says that from 10th of February 2025, those who enter the UK illegally will normally be refused application for naturalization if they made such application because of their background. And so if you ask for priority service, the priority service will not be possible because your background is such that the caseworker will need time to be able to assess your application to make clearer and fair decision on your case. So who is this for simply? It's for people whose situations are so straightforward, direct. For example, somebody who has been in the UK for 10 years, long residence, and they've been legitimate throughout. The person can apply on the basis of set LR application, and that so on the basis of naturalization, having had their indefinite issued to them. Such person, everything is clear. They entered the UK legally, they went through the process, got their indefinite, and they are now applying for naturalization. There's nothing else apart from giving them the information they need from you to assess your application under Section 6, Schedule 1 of the British Nationality Act of 1981. Straightforward. Or somebody who came to the UK as a spouse, 2.5, renewed for another 2.5, still living with a husband or wife, and obtained indefinite leave to remain under set M, was granted. And the rule said that if your husband or wife is a British citizen, you can apply immediately for naturalization after your indefinite has been granted. So this person goes ahead to apply. You can see that the trajectory is that everything is on point, everything is met. And so you don't really need rocket science to know that this is a straightforward application. Such a person can opt for a priority service because there is really nothing serious about their background for the caseworker to say, I need more time. These are the nuances and these are the instances, and therefore you check your background to know whether you should waste £500 or you should use £500.
Thank you very much for your very detailed explanation on this new update. So please, before you go and waste £500 or spend £500 on a priority application, please make sure you check your background and see if you are eligible, because it's not for everybody. So we are going to look at our nuggets. Our nugget for this week is: a person can apply to the High Court or Family Court in England and Wales for a formal declaration of parentage. This legally confirms whether a named person is or is not the biological or legal parent of another individual. If the order is granted, the court notifies the Registrar General to amend the birth certificate of the child concerned. This is from Section 55A of the Family Law Act of 1986. We'll go back to Lawyer Charles to explain this to us.
Right, thank you very much. Yeah, so the position of the law is clear. Somebody can go to court, and there are two gateways. You either go to the High Court or you go to the Family Court. It's a choice. Both are correct. Why will you go to court? You go to court because there is contention between the 2 or the 3 or the 4 men who are fighting over the fatherhood or paternity of the child. And we start with the basic or the default position of Section 2 of the Children Act of 1989, which says that if a child is born, the child's birth ought to be registered, and the named parent on the birth certificate will be deemed to be the parent. And the named parent will be mother, father on the birth certificate. And therefore, the father named on the birth certificate is the father of the child, Section 2 of the Children Act 1989. There's also contention under Section 50, subsection 9, capital A of the British Nationality Act of 1981. And the contention is that somebody who was born to, or a child who was born to another man, and the mother at the time was married to another man. In that case, there are two men here. We have the legal man and the biological man. The biological man is the one whose sperm created the baby. The legal man is the one who is married to the child's mother at the time or date of the birth of the child. Question: who is the father? The law says that legally, the man married to the woman is the father, because if the biological father is not known anywhere, and the legal father or the one married to the woman is also saying that I don't want this baby, the default position will be that this child will become a bastard. A bastard is simply a child without a father. And so, to avoid that, the law was amended to reflect that position, that where children are born and then at the time the mother was married, the father will be the man married to the woman or the mother of that child. That is the default position within the rules. And therefore, in assessing who the father is, we can look at the marriage at the time and whether the woman was married. If it is, we look at when the child was born. If the child was born at the time when the mother was already married, then the man married to their mother is the father. Somebody will also say that, yes, but the birth certificate also shows that a different father's name is there under Section 2 of the Children Act. So how do we resolve the contention where marriage is creating right of paternity and DNA is also creating right of paternity? Where do we resolve the dilemma? And then in this case, we have to go to court for the court to resolve it. And the court says that we can resolve this controversy under Section 55, capital A of the Family Law Act of 1986, wherein the man aggrieved will go to court and present evidence of parentage, in this case, paternity evidence through DNA. Court will assess the evidence, and if it is proven that he is the biological father of the child, then a declaration will be made for him to be named as the father. And subsequently, an order will be made by the court for the birth certificate of the child to be reissued to reflect the new status of who actually the father is. There's also a case law, the case of Ray X, a child. It's a 2025 citation wherein the court was clear that in determining who the father of the child is, you have to assess the situation holistically and around. You can conclude that the father is the one under Section 50, subsection 9, capital A of the Nationality Act, or the father is the one under Section 2 of the Children Act of 1989, or the father is actually the one that the court has now declared to be the father. That is the situation, and therefore somebody can go to court and have the father changed from A to B upon declaration and order.
Wow, thank you very much for your explanation, Lawyer Charles. We are live on BWF Solicitors and at BWTV on YouTube and Facebook. So please share this with your friends and family so they can join us and learn something new today. They could also get their questions answered. You could put your questions down in the comment section. When it's time, Lawyer Charles would give you answers to any questions you have. Further down the line during this program, we shall also open the studio lines for you to call in and ask any questions you will have. So BWF solicitors are located at Seven Sisters in North London. You could go to them when they are open. That's from Monday to Friday, 9:30 a.m. to 6 p.m. for any immigration issue you may have, family issue, civil issue you may have. They are the best at what they do. You could locate them at Seven Sisters. You use the Victoria line. When you get to Seven Sisters, you get off at exit 2 and you would be directed straight to their offices. It's on the 4th floor of Anna House. That's 214 to 218 Tottenham High Road in London. The postcode is N154NP. Before you go there, please make sure you book a consultation. You could call the office on 0208 493 7340. That's the office number. You could also call their Ghana number on 055 589 5959. And in the case of an emergency, you can call them on 077 1276 1884. So I'll take these numbers again. The UK number for calling to book your consultation is 0208 493 7340. Their Ghana office number is 0555 895959. And in case of any emergency, you could call 077 127 61884. So now we are going to look at the quiz question which we gave for the week, which we would look at further down the line and see the answers many of you gave and see which of you had them right and which of you had them wrong. So our quiz question for the week was, Yoni had an affair with Lodi, which resulted in the birth of Pansy. They registered Pansy's birth and had Yoni's name appearing on Pansy's birth certificate as the father. A year later, Ahmed came forward to challenge Lodi that he is the father of Pansy. Advise Ahmed. So the answers are 1. Ahmed cannot do anything about the situation. 2. Ahmed can apply to the High Court for a declaration that he is the father. 3. Ahmed can apply to the family court to seek a declaration of being the father and for an order to have him named as Pansy's father. And then the 4th one, all of the above except option 1. If you look at our nugget for the week, you'd be able to answer this question. So further down the line, we'll have a look at your answers, the answers you gave. So we are going to take a short break, and when we come back, we will dive straight into our topic for discussion.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Once again, we are live on the Community and the Law, sponsored by BWF Solicitors. We are live on YouTube and Facebook at BWF Solicitors and at BWTV. Please share this video as many times and as much as you can to your friends and family so they can join us. Like the video, comment on the video, and please on YouTube turn on your post notifications so you are notified every time we post a video or every time we are live. So our topic for today is going to be treated by our very knowledgeable resource person, Charles Asma. Our topic is, can I divorce in the UK if I married abroad? So as I said earlier, this is a question we have been getting a lot because a lot of people have come into the UK with their partners, and unfortunately the marriage has broken down, and now they would want to separate and get a formal divorce, but are unsure whether they can do that in the UK since they did not get married in the UK. So we are going to have lawyer Charles Asma advise us and explain if this is possible and the steps you can take to get your divorce. So please, over to you, lawyer Charles.
Thank you very much, Pamela. Amazing. So, viewers and listeners, the question is either yes or no. If yes, why? If no, why? The answer is yes. You can divorce in the UK even if you married abroad. Reasons. Reasons are set in law, and so we'll be referring to the basis of divorce within the UK. What we're going to do is first off look at the key things for discussion. We'll look at how the process of divorce works within the UK. So we look at the law, we look at grounds for divorce, we look at the process involved in the divorce, and we look at who can bring application or request for divorce in the UK court. We look at which court, and we look at whether the UK court has the power to do so if anybody presented a request to divorce. So that I will finally conclude to say that yes, you can divorce in the UK even if you married abroad, subject to meeting certain conditions. So, producer, please, you help us with getting divorced in the UK resource. From there, we'll look at the Matrimonial Causes Act to 1973, and finally, we'll move on I said, so, give us the other one before this. Give us this one. Right. So my host will help so that we go through together. We'll make it somewhat interactive. So it says get a divorce. These are the key things, and this is the UK government website, so gov.uk divorce. So the first thing is that check if you can get a divorce. So Pamela, if you're available, you are going to lead on that, and I will offer clarification to that. What do we check?
Okay, so you can get divorced in England or Wales if all of the following are true. 1, you have been married for over a year. 2,
So
your relationship has. Oh, should
yeah,
I
so
read it all or should we take
we
it?
take it one, yeah, we take it in tense.
Okay, so the first one is you've been married for over a year.
So here we are not told where in the world. It says if you are married for over a year, whether you married in um, in space or you married wherever, it doesn't matter. It says you have been married over a year. So what do you need to prove that you've been married? What do you think?
Your marriage certificate.
The marriage certificate, as long as it is valid, it is evidence that you have been married, and the date will tell whether you've been married for at least 1 year. It doesn't matter which country or which part of the world. And that is the beauty of the UK law. Next.
So the second one is your relationship has permanently broken down.
Yes, so the relationship should have broken down permanently. What we say, it has broken down irretrievably. Prior to the changes in the law, somewhere in 2024, 2023, you needed to show one of the five reasons. One of the five reasons, what we say, the cause of the breakdown. This time, you don't have to show the cause of breakdown. All you have to say is that it's broken down. How it broke down is nobody's business. And that is all. And again, the law is simplified. So you just have to say that the marriage is broken down and that it is no longer able to survive or come alive. And so it is breaking down irretrievably or permanently. Then you have to also show that there have been attempts to resurrect it, and yet it is not able to resurrect. Then that is permanent breakdown. And yes, next.
The third one is your marriage is legally recognized in the UK.
So the marriage should be legally recognized in the UK. So somebody will ask, if I'm married abroad, producer, are you able to put us side by side somewhere so that viewers can see and follow? Yeah, so the question is this marriage recognized? How is marriage recognized in the UK? Because you are relying on the marriage certificate to prove that you married, you have to show that that marriage is recognized. And the law says that if the marriage followed the process required in the country where the marriage was contracted and it is valid in that country, then it ought to be recognized in the UK. And so it doesn't really matter which country. Insofar as you follow the process and that marriage is valid in that country, UK Family Court will accept it and conclude that it is recognized. There's echo in the background. I'm not sure where it's coming from. Yeah, let's continue. Right. So these are the three key areas we will have to look at in terms of how you are going to seek divorce in the UK. Then we move on to the next thing on the checklist, producer. Producer, next. No, next is on the same thing. Next is before you apply. Okay. So,
Okay,
yeah.
before you apply, you must decide whether you want to make a joint application with your husband or wife, or whether you want to apply on your own.
So you have two options. You do on your own, or you decide together that we are going to seek together divorce. If you decide that you go together, that is joint application. In this case, you don't need permission from the other person for the court to continue. If you go sole or on your own, then the court will require consent or permission or response from the other party. And the whole process takes about 7 to 8 months in the UK. And if it is joint, it's faster because there might not be any need to go and ask the respondent or the other party whether they agree or disagree. If the other party disagrees, then of course the process will take longer because then it might be contested. But if the other party so agrees that yes, let's go ahead, then the court will conclude that there have been response from the other side, and so we go ahead with the proceedings to issue. Next on the checklist, please, producer. No, I think sorry. If you go out, yeah, I think it's all showing here. All right. So we've done so applying for a divorce on your own. If you're applying on your own, the entire process is that you make the application to court. The application will be made online and you pay the court fee. The court fee is £612. You pay online and the court will accept the application to process. It's online, and therefore, of course, the person must have access to computer and internet. That is all there is. So if you go online to get a form to complete and you submit or post the form, that is wrong. Because it's supposed to be an online, not a paper-based where you print the form and fill out. Now, because the conversation is not about children, it's not about property, and it's not about how to settle the finances, we are leaving out the financial settlement aspect and the child arrangement aspect. We are going into the discussion, or we are looking at whether somebody who married abroad can seek divorce in the UK. Right. Now, so producer, at this point, let's go to the Matrimonial Causes Act 1973, the second resource. All right. So if we go to the table of content, please. The table of content on the left. Table of content. Okay. Oh, yeah. Okay. Yeah. So if you please help me to access because I can't see clearly. Right. So it says divorce on breakdown of marriage. It says bar on applying for divorce. And we look at refusal. But the key thing here is that divorce on breakdown of the marriage. So the UK court will look at this law and the checklist that we went through earlier on before starting to make a decision or to process the application in the first instance. So we go straight into the discussion. So producer, now you can take off the resource and we go into the explanations. So we know that somebody can bring a case seeking to start divorce proceedings against a party to the marriage in a UK court. And it has to be UK family court. And as we said, it's an application made online. Now, we know that the person might have been married for at least 1 year. We know that the relationship should have ended or broken down to the extent that it can never be brought back to life. That is irretrievable breakdown of the marriage. we have also understood that both parties can make one application called joint application, or one person can make that application called sole application. Question: is it possible for a UK court to say, we are sorry, we cannot accept this case because we don't have the power? And that is called jurisdiction. The jurisdiction is that the person or persons seeking divorce in the UK must prove that they are resident in the UK. Resident simply means that they are habitually resident. What does it mean? It should be somebody who lives in the UK, not someone who has just visited the UK. How do you prove that somebody is living in the UK? A person living in the UK must have a visa of at least 1 year. A visa of at least 1 year. And this should not be a visitor's visa. So if you have a visa that allows you to live in the UK, and the visa is at least 1 year, and it is not a visitor's visa, then you have 1 point. Then the second point is that the person should have lived in the UK for at least one, so that's the habitual residence, living in the UK for at least 1 year. Or, and in this case, either both parties or one of the parties. There are a list of things, but the key thing is whether you are resident in the UK or you were resident in the UK within the last 1 year before the proceedings started. Most of the time, if the person is living in the UK and has lived in the UK for 1 year, then it ticks the first box for jurisdiction for the court. So for the UK court to show that they can accept the application and take it through in terms of the proceedings, the person, which is the applicant, must prove to the court that they have been living in the UK for at least 1 year. Either you have domicile in the UK or you have habitual residence in the UK. Domicile in the UK means that you live in the UK because you have British citizenship or you have indefinite leave to remain. Habitual residence is that you may not have indefinite leave to remain or British citizenship, but you are living in the UK, and living in the UK habitually means that you live in the UK for at least 6 months or more. 6 months or more. And the whole thing is that even if you are a British citizen or someone with indefinite leave to remain, and you have not been living in the UK because you live abroad, then once you come to the UK seeking divorce, you have to wait. You have to stay on for at least 1 year so that the power that the UK court will have can be activated for you to be able to bring your application for divorce. The next thing is that you can bring the proceedings to a UK court, provided divorce has not yet started elsewhere. Let's assume that a person married abroad, in Ghana, Nigeria, wherever, and they have already begun proceedings and they want to convert that to UK court proceedings. That will not be possible because divorce has already started. So yes, you can, but make sure that it has not been already started elsewhere. The next thing is whether there has already been divorce. If divorce has already taken place elsewhere, then you cannot bring the same marriage to be divorced or ended in a UK court because you cannot divorce twice. So somebody may say that, oh yes, but my wife or husband divorced me abroad, I wasn't aware, and so on and so forth. If you're not aware, and you can prove that you are not aware, then that divorce can be invalid. If it is invalidated, then you can begin a new divorce process in UK or in another country or the same country, depending on the circumstance. So let's take note that if divorce has already been settled elsewhere, you cannot start again in UK. Number two, if divorce has ended and issued elsewhere, then you cannot reopen it in UK court. And 3, if you are not habitually resident in the UK, then you cannot begin divorce proceedings in a UK court. So we pause here and take the conversation forward.
Thank you very much, Lawyer Charles. So I hope you have heard so far what Lawyer Charles has said. He has made some very important points on how you can get divorced in the UK, although you are married in a foreign country. So yes, the UK can take jurisdiction and you can get divorced in the UK, although you married in a different country. We are once again live on BWF Solicitors and at BWTV on YouTube and Facebook. We are still going to open the studio lines a little later for you to call in and ask your questions. You can also put your questions down in the comment section. We will read them and then Lawyer Charles will give you answers to whatever questions you have. We would also look at the quiz and then look at the answers you've given us. For now, we are going to take a short break, and when we come back, we will continue with this very, very educational topic. See you in a bit.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Good afternoon and welcome back to another edition of the Community and the Law. Our studio lines are now open and you can call in to ask your questions. Our studio number is 0208 493 7345. I repeat, our studio number is 0208 493 7345. So please feel free to call in to ask your questions. Lawyer Charles, thank you very much for this educational topic. I just have a few questions that we've been asked around this topic. What if people start with their divorce proceedings like a sole application, but then there's no response from their other partner? So they have started the application, they have sent it to their other partner, and there's no response, absolute silence. What do they do from that point on?
Right. So the court has power to declare that the other party has been served, because there must be service of notice. So the court will first send a message to the other side. There will, of course, silence, as you said, either email or post. There's still silence, because at the time of application, the person must indicate the last known address of the other party and their email address. So both will go, email and postal service. The person must respond. But what if they've moved on, they've changed their address, or nobody knows where they are? Because this person doesn't know where the other party is. The procedure then will be that the person who made the application must appoint a process server. So must request the service of a process server. A process server is an agent who will personally send the letter to that other party. So the person will go to the address several times, and the moment they open the door, they will give it to them that this is for you, take a picture, and that's evidence of service. Whether they will respond or not is their business. At least they have been given. Because the argument they are making is that I haven't received it. But if we now know that you have received it and you haven't responded, then it is deliberate as opposed to not being aware. So that's one point. The second point is, if they go to the property several times and still they are not able to meet this person at home, what they do is that they drop it in the letterbox and take a picture to show that it has been served. That is also one way. After that, you make application to the court, show them the evidence, and for the court, because the process server will provide you certificate of service, then the court will be requested to make an order that the application, the service has been completed, what we call deemed service of notice. And once the court says that the person has been served by deemed service, that's the end of matter. Court will go ahead if they fail to still respond.
Okay, that's interesting to note. There is a situation, I've come across a situation where a person wanted to have a divorce, but she did not even know the last known location of her partner. So she knows that he has moved out of, his accommodation. She has no idea what his email is, what his telephone number is, what his address is. In this case, she doesn't even know if he's still in the UK or has completely left. Is it going to be the same? Are they going to just serve it at the last known address, or they will have to do some kind of extra searches to find where this person has gone to?
Right. So there are instances where you have to carry out searches, but I mean, to what extent? And so the court says that the last known address of the respondent or of the other party, and your job is to provide that address. If the person has not been responding, then the court will have to ask you to follow through the deemed service process. This is where the process server will have to go to the last known address and personally serve, or just drop and take evidence that it's been dropped, and it's up to the person to respond. Whether they live, don't live there, nobody can tell, and it is not the applicant's duty to find out. So once you go through that tick box exercise, the court will agree that you reasonably follow through the process and you did the best you can as far as service is concerned.
Okay, thank you. So what about in situations where they've started with the divorce process and now they have reconciled and now they want to just drop the whole divorce proceedings? What do they do from then? Do they just stop it? Is there a way they can stop it? How do they just stop because they've reconciled and no longer want to progress with their divorce?
So that's the beauty of the UK divorce proceedings, because it accommodates for situations like this where the parties reconcile and change their mind to say that, you know what, we don't want to divorce anymore or any longer. So the first stage is that before you even begin the proceedings, you would have gone through the mediation process. So the court will ask you, have you completed mediation with a view to resolve your misunderstanding that broke down that relationship? If the answer is yes, court knows that you've done your part, so court will have to start. Again, the court will give you the first certificate after 21 weeks, the first certificate. The first certificate is called conditional order. It used to be called decree nisi or nisi. It's now changed to conditional order. Once we have the conditional order, what it simply means that this is a certificate, but not the final, because in case there is a change of mind and you decide not to continue, this can easily be discarded. So they will not give you the actual certificate, just in case you have changed your mind. So once you are given the provisional certificate, let's call it, but actual word is conditional order. Once you are given the provisional divorce certificate or the conditional order, you have about 6 weeks for you to think about whether to really go for it or not, or end it or not. Once you change your mind within those 6 weeks, you can go to court and say, we've changed our mind. We are no longer going ahead with a divorce. And then the court will not grant the final order or pronounce divorce completely. So there's still a way for people who have changed their mind to do so, but they have to do so before the final order is issued. And once the final order is issued, that is the end of the process. And then if you say that we've changed our mind and we want to come back to it, then you can start again and marry again. And if you want to go through marriage, or maybe at that point you can come back together as unmarried partners and live your life without any string of marriage, so to speak.
Okay. Thank you very much. So once again, our studio line is opened. Our number is 0208 493 7345. You can call in with any questions you have. We've got a few questions from our viewers today. So we've got Citizen Kojo, who is asking, Kofi was arrested for driving with a provisional license and on suspicion of driving under the influence of alcohol. The police requested a breath specimen to test his alcohol level, but he was unable to provide 2 consistent breath samples. As a result, he was arrested and taken to the police station to provide a specimen there. At the police station, he was again unable to provide a breath specimen because he was experiencing chest pain. Despite this, he was charged with failing to provide a specimen for analysis on the basis that the police considered he had refused to provide the required sample. He was provided with a duty solicitor, but despite several attempts, he has been unable to make contact with the solicitor before his court date. What can he do in these circumstances? What are the possible outcomes of his court case if he can show that he was medically unable to provide a specimen rather than refusing to do so? Also, if he is convicted, could this have any impact on his future immigration or visa renewal applications? Wow, what a question. Lawyer
Okay.
Charles.
Right. So the key thing is, I have been charged with drink driving offense. And the background is that, producer, you can take off the question. So the background is that I failed to provide the sample my breath sample. It wasn't intentional. So there's a reason, a mitigation. He has to prove that there is indeed mitigation. And because it borders on medicine and medicals, it has to be an expert to provide the report or evidence that somebody may have difficulty to provide the breath sample under that circumstance. If it is indeed the case, from the consultant or the expert viewpoint, then the person will have a reason. In that case, it will not be possible for the person to be potentially charged. But the key thing is, did you? So if because a drink driving offense, if it is not possible to prove that he had taken alcohol or he was drunk, then you cannot proceed to charge or convict or prosecute, so to speak. At this point, the person has been charged. The next stage is the prosecution and the conviction. To be able to confirm that indeed the person is guilty as charged, expert will have to come in because the person is disproving this. There's what we call summary offenses, strict liability offenses, and offenses that ought to be proven. Strict liability offenses are offenses that have happened. And here, you don't need the mens rea to confirm that the person did it deliberately. It's happened and it is. It's just the actus rei or the action itself. Now, what is the action? You have driven, and at the time you were supposed to stop, you didn't. What we call, you've jumped the red light. So jump the red light, it's an offense, strict liability. You don't have to explain yourself because we see the red at the time and you went through the red without stopping. Strict liability. You don't have to say because of this, because of that. You don't have to really justify anything. Again, somebody who is overspeeding, it's obvious on the fact that the action is enough to confirm the charge. And so again, such strict liability offense, you don't need to prove anything. But when it comes to drink driving, the alcohol has gone into your system. You cannot see on my face, and you cannot see just by looking at my body. So how do you tell that I have alcohol in my system? It is the breath that will determine that it's being taken out of whatever is in the system or the chemical or substance in the system. So if you ask me to breathe and I'm having difficulty breathing, you cannot get the evidence to charge me. So what I'm telling you is that I can't breathe. You are saying, no, you can breathe, but you have refused to breathe because of what you are hiding. Question, is it deliberate or not? If it is not deliberate and you don't have the evidence, how do you then charge me? So this person has been charged, and the whole thing is that you refused or failed to provide sample under request. And so we've charged you for drink driving and failing to provide a sample for assessment. Question, did I fail? Yes. But was it deliberate? No. Why? Because my health is such that I cannot breathe. Maybe. If that is the case, a medical consultant or expert will have to come in to confirm that the situation the person found him or herself is such that medically they can't breathe. If that is the case, will you be able to pin me down? No, because there's no evidence to pin me down. The person, nothing can happen to the person in court. But if the medical expert says that regardless of the circumstance, if you are to breathe, you should be able to breathe in and out without difficulty, then what they will say is that if that is what the expert is saying about our health, about everybody, then you failed because you could have still done it. Now, these are the differences. The question is, if I'm charged and convicted, will it affect my immigration? Yes, because when you are making an application under suitability, part suitability, questions there. One, have you been charged with any offense? You have been charged with offense and you have been convicted of an offense. So the answer is yes. then you have to explain the circumstances. The next stage is whether you, in this case, it's quite straightforward. It's not about warning or caution or anything. It's a charge, and the charge is even progressed into conviction. So, have you been charged? Have you been convicted? Have you been prosecuted? Are you waiting for court hearing? Yes. What happened? Then you have to give an account. Will this be detrimental to your case? Potentially, depending on whether it goes above the threshold or below the threshold. What is the threshold? The threshold is the level of mitigation, where the caseworker will think that this is a serious offense and touches on public interest, or this is not so serious and therefore can be waived by exercise of discretion on the part of the caseworker. What is the issue? Driving or overspeeding? I think this person was overspeeding. So overspeeding. If you overspeed, that's bad behavior. But is this so serious to the public? What could be serious to the public is that potentially you killed as a result of overspeeding and you have a habit of doing that. Then it will be difficult for you to be part of the community. But in this case, nothing happened. Yes, they oversped and so on and so forth. But has anything happened to the public? Nothing really. And so, should we punish the person to say that because of this, they cannot be part of the public as far as their immigration status is concerned? That would be harsh because it doesn't go beyond the threshold. And therefore, a favorable discretion can be exercised by the caseworker on the basis of the circumstance and the fact that there has been mitigation. What is the mitigation? The period of time. The person maybe has been banned from driving, the person has gone through the training, the person has reformed, and the person has understood the consequence of doing this again. Again, over the period of time, how long has it been? A year, a month, a day, or a week? The longer, the better. And therefore, putting all this together in a round, we can say that on a balance of probabilities, you should be able to give explanation that yes, it happened. However, it should not go against you as far as your immigration status in the UK is concerned.
Thank you very much. Our next question is from Patrick Kosobo. He says, what should a dependent whose wife refused to add him to her new sponsorship do? His visa is expiring next week. He doesn't even know her whereabouts.
The person is just like asking, what should somebody who is hungry and doesn't have money to buy food do? If you are hungry and you don't have money to buy food, well, you drink water, so to speak. But will water survive you throughout? Well, it's a matter of the circumstance. So if your wife says that the relationship is broken down and they have left you and they have moved on, what should you do? Advise yourself and move on as well, regardless of how long you have left on your visa.
Excellent answer. Patrick, please advise yourself and move on because you probably do not have much time. We've got another question from Nanani. She or he is asking, Angela has a Ghanaian district court order dated 19th May 2026 stating that her ordinance marriage has been dissolved and that the parties are free to remarry. However, it also states that the marriage was customarily dissolved on 23rd May 2025 for UK skilled worker visa purposes. Can she safely rely on this court order as proof of divorce? If so, which date should be entered as the date of divorce?
Well, I don't know whether Nana or is Angela. Angela went through the process properly because there's nowhere in the world where a piece of evidence of divorce should show two dates. Customary dissolution is where we're saying that the families accepted that the process has ended. But once it goes to the registrar will only say, because compared to marriage certificate, the marriage certificate will always show date of marriage and date marriage was registered. But divorce, we don't have date of divorce and date of registration of divorce. The registration of divorce is the date of divorce. So you can't have home divorce and court divorce, unlike marriage. And so this is defective. You have to go fix it.
Thank you. Angela, please, you need to go fix that because you can't have two dates on your divorce. So our next question is from Cecilia Tre. She's asking, how long does a child fee waiver for naturalization application take? My fee waiver has taken more than 4 months, but I have not heard anything. Please, can follow-up be done at the Home Office? Thank you.
Okay, yes, if you want to follow up, you can follow up. But 4 months, is it too long? Not really. Can you wait? If you can, please wait. But if you can't wait, you can follow up.
Okay, thank you very much, Lawyer Charles. Please, our phone number, our studio lines are now open. Once again, you can call in to ask your questions, 0208-493-7345. We are going to have a look at our quiz and see the answers that were given by our viewers. So, producer, if we could kindly have the quiz. So the quiz question for the week was, Yoni had an affair with Lodi, which resulted in the birth of Pansy. They registered Pansy's birth and had Yoni's name appearing on Pansy's birth certificate as the father. A year later, Ahmed came forward to challenge Lodi that he is the father of Pansy. Advise Ahmed. So the possible answers were: 1. Ahmed cannot do anything about the situation. 2. Ahmed can apply to the High Court for a declaration that he is the father. 3. Ahmed can apply to the family court to seek a declaration of being the father and for an order to have him named as Pansy's father. 4. All of the above except option 1. So we're going to see what you think the answers or the answer is to this question. We've got Patience Boating, who believes the answer is 3. Ahmed can apply to the family court to seek a declaration of being the father and for an order to have him named as Pansy's father. Kobe Boache also believes the correct answer is 3. We have Michael D. Boating, who is also gone for option 3. We've gone for Franklina Opong, who's gone with a different answer, and she has gone for option 1. We've got Barbara Sewa, another different opinion, which is option 2. She believes Ahmed can apply to the High Court for a declaration that he is the father. Kofi Asari agrees with her and has also gone for option 2. We also have Charles Abram, who is also gone for option 2. So we've got option 3, option 2, and option 1. Oh, finally, we've got somebody who says option 4. This person is Godfred Akoto-Boafo. He believes Ahmed can do all the above except option 1. So he believes Ahmed can apply to the High Court and Ahmed can also apply to the Family Court. We've got Felicia Osei, who has gone for option 3. It's very interesting that everybody has gone for their different opinions. We'll see the answer shortly. We've got Wisdom Shelf, who's also gone for option 2. We've got Juliet Oko, who's also gone for option 4. And we have Georgina Ado, who believes Ahmed can apply to the High Court for a declaration, which is option 2. Michael Oti Entry believes Ahmed cannot do anything about the situation, which is option 1. Then Eagle Okodi believes Ahmed can do all the above except option 1. That is option 4. It's his choice. We've got Letitia Amponsa, who has also gone for option number 2. We have Abna Menu, who's also gone for option number 2. Ahmed can apply to the High Court for a declaration. So we've got, different opinions. Everybody believes something. At least with this quiz, we've got answers from 1, 2, 3, and 4. None of the options have been left untouched. Everybody believes it could be 1, 2, 3, or 4. So we are going to go to Lawyer Charles to give us an explanation and give us the answer. And then we'll come back and tell you who got the correct answer, who got it right and who got it wrong. So over to you, Lawyer Charles.
Thank you very much, Pamela. Yes, so go back to the reference point. It's always important to refer to the root of the issue or the law. So what is the legal position? The legal position is that somebody like Ahmed, in terms of contention, has a right. And his right stems from two angles. What are the angles? Go back to the nugget. So Ahmed, we are told that he can go to the family court, right? The person can apply to the family court or the high court. So two places. He can go to family court, he can go to high court, not only one. So if you're advising Ahmed, you can say, Ahmed, you know what? You can go to two places, family court if it's close to you, or go to high court if it is your next door. So he's got two options. And those two options are stated within option 2 and option 3. Option 2 and option 3. So option 2 and option 3 are correct. But the question says that, or the answers say that you can have option 2 and option 3 except option 1. What is option 1? Option 1 says that Ahmed should just relax. He's missed the point. He has to suffer forever. There's nothing he can do. No. Section 55, capital A of the Family Law Act of 1986 says that Ahmed has right within the law. So those who say Ahmed should not do anything, that is not the best advice for Ahmed. Those who said Ahmed should go to high court only forgot that Ahmed has another option of going to the family court. Those who said Ahmed should go to family court only also forgot the option Ahmed has that he can have family high court. But those who said that Ahmed can go to family court and the high court, which is 2 and 3, except number 1, are right. And so the answer is 4. All of the above except option 1.
Lawyer Charles. So our answer is 4. So congratulations to everybody who chose 4. Ahmed can go to both the high court or the family court. Please don't forget, the answer is in the nugget. So before you answer our quiz, read the nugget and read it carefully. Next week, who knows? You might just be lucky and you might actually win. That's if you read the nugget. So the answer to the quiz is 4. Ahmed can apply to the high court or the family court to be declared as the father of Pansy, and an order to be able to replace Yoni's name with his name on Pansy's birth certificate. A person can apply to the High Court or Family Court in England and Wales for a formal declaration of parentage. This legally confirms whether a named person is or is not the biological or legal parent of another individual. If the court's order is granted, the court notifies the Registrar General to amend the birth certificate of the child concerned. This is found in Section 55A of the Family Law Act 1986. So as I said, please, for next week's quiz, please read the nuggets. You'll be able to get the answer correct. So congratulations to everybody who chose 4, and please don't be discouraged. Next week, put your answers in again. Who knows? Hopefully you would get it right next week. So thank you very much, Lawyer Charles, for explaining this, and thank you for the very educational topic we have discussed today. If there's anything you'd like to add before you close us off.
Right. So by way of summary, the answer to the question posed within the topic is yes. Can I divorce in the UK if I'm married in another country? Yes. How do I do it? Show that you've been married for at least 1 year. Show that your marriage was valid in that country. Show that you live in the UK habitually, i.e., you don't just come on holiday, but you live here and you have been living here for at least 1 year as somebody with visa to live in the UK, indefinite leave to remain, or citizenship. You also have to show that the divorce has not already started in another country. You also have to show that the divorce has not started and ended in another country. And you have to show that the UK court can accept your application, i.e., you are habitually resident or you are domiciled in the UK. You make an application online, pay the fee of £612, and 612 means £612. You have to show that you have the address and the email address of the other party. You do it together or you do it alone and the other party will approve of it. Once you go through the process, the court will then want to know whether you have had opportunity to change your mind. Once that is the case, you have 21 weeks to wait for the first certificate and another 6 weeks to wait for the final certificate. Between the final certificate and the first certificate, if you change your mind, the court will end the process and reverse the proceedings so that you can go back and live as man and woman again. If not, once the divorce is and the proceedings are ended and the final order is issued, you are pronounced divorced. And therefore, once you change your mind, you have to reinvent the wheel, either marry again or decide not to even bother about marriage, by just be living together as man and woman without marriage. These are the conversations we've had today. And therefore, those who married abroad and are considering whether they should go back to your country and divorce or you can divorce in the UK, you know that you can stay in the UK and divorce in the UK family court by going through the process. This is what we brought you today. Thank you.
Thank you very much, Lawyer Charles. Thank you to all our lovely viewers for tuning in with us today. I have been your host, Pamela Oakley. Our resource person has been none other than our very knowledgeable and well-educated Lawyer Charles of BWF Solicitors. Once again, you can go to BWF with any immigration issue, family issue, civil litigation issue. They are very good at what they do. They are located at the 4th floor of Anna House, 214 to 218 Tottenham High Road. The postcode is N154NP. You can get there with the underground Victoria line. You get off at Seven Sisters, use exit 2, and you will be right in front of their office. You can also call them to book your consultation on 020-8493-7340. I'll repeat that. Their office number is 020-8493-7340. The Ghana number is 0555-895959. And in case of an emergency, you can reach BWF Solicitors on 077-1276-1884. I would just like to put in there that emergency number is strictly for emergencies, please. If you want to book a consultation, please call the office number, because you may probably not be having an emergency and you would call the emergency line, which that's not the point of having the emergency line. So please call the office number for your consultations. Emergency line, strictly for emergencies. Thank you very much for joining us today. This has been the Community and the Law. We hope to see you again next week. And please don't forget, it's really hot. So carry your bottles of water and your fans anywhere you are going, so as not to get dehydrated or too hot. Thank you very much. Have a blessed weekend.